Hi everybody, and thank you for joining Legal Aid Queensland for our webinar, Understanding the Domestic Violence Order Application Process and Referral Pathways for your clients. My name is Catherine Bowden. I work in the Community Legal Education team here at Legal Aid, and I'd just like to start by acknowledging and respecting the First Nations custodians on the land where our office stands in Brisbane CBD, and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. And we pay our respects to their elders, law, customs and creation spirits, and recognise that these lands have been places of ceremony and teaching, research and learning. And we just acknowledge the important role that Aboriginal and Torres Strait Islander people play in our community and improving our legal system. Next to me today is Daisy. Daisy is a Referral Pathways Officer in Family Law Services. So thank you, Daisy, for joining us today. I'd just like to mention a trigger warning. The webinar will contain content related to domestic and family violence and will involve just a discussion of topics which might be confronting to some people today. So please just consider your own safety and your own well-being, and if at any point you decide that you don't want to continue listening to our webinar at this time, that's completely understandable. Please sign off and take care of yourself, and if you do feel like you're in a place where you'd like to listen to it at a later stage, then we are recording it today and it will be published on our YouTube channel. We've got some hotlines there if you feel that you would like to reach out to anybody today. Just a bit of housekeeping. The webinar is being recorded, as I mentioned, and it will be published on our YouTube channel.
Oh, do we need to go full screen?
Sorry, just full screening this today. All right. If you'd like to download the handout, we've got quite a few here today. So the presentation slides is understanding DVOs and referring clients into legal aid. We've also got some other handouts here which we can also send the links around to. Some of the files are quite large, so if you can download it, please do. If you can't, don't worry, we'll send the links around to you. If you'd like to ask Daisy any questions, she is open to taking questions along the way. We have just an amazing list of questions that have already been asked from our audience, so thank you so much to everybody for sending those through. We've got them all here and Daisy's ready to ask those throughout the presentation as well. I've got someone jumping in just saying thank you for making it an accessible webinar, and that's, thank you, a good reminder to me just to let you know that we have a live captioner here today, and we also have 2 Auslan interpreters joining us as well, and they will be included in the recording which will be on YouTube. So if anybody's planning on sharing this with any of their colleagues or using it as a training module in our team, then it will be made accessible in the recording as well. All right, we're going to jump into a poll. We've got polls along the way that will just help frame the webinar. So we're interested in our audience, in where you work, if you're from Southeast Queensland, Far North Queensland, if you're currently working in regional Queensland, and I know we always have quite a few people from outside of Queensland as well. So we are based in Queensland, and the topics that we're talking about today are very relevant to people working within Queensland. You're still very welcome to join us if you are outside of Queensland, and Daisy's going to just touch on that for us in a minute as well. I can see most people are within Southeast Queensland, but we have a really great number from Far North Queensland and regional and outside of Queensland as well. So thank you for joining us. All right, we're interested to know what your role is today. If you're a family worker, a community worker, a support worker, or if you work in the health industry or education, if you're a social worker or a lawyer. I can see we've got a really even spread here actually between family, community and support, social work and lawyers. And just a reminder that our polls are not captioned today, or there's no Auslan interpretation or live captioning on the screen during the polls, as they do tend to take over. So we'll close that off today. All right, and this is going to help guide the level of knowledge for Daisy as she moves through her presentation. How often do you help clients apply for a domestic violence order? I know for a lot of you this could be a weekly or a daily task as part of your role, and based on your client's needs. For others, this might only come up once in a while, but you're here because you need the information for a specific client, or you'd like to be prepared in case it ever does happen. And again, we've got a really even spread of people here. Probably say most of you help clients apply for a DV order sometimes and rarely. So Daisy's got a lot of really great information to touch on these soon. All right, I'm going to hand you over to Daisy. Thank you for presenting today. I'm going to let you talk about what you're going to cover and move through your presentation.
Yep, wonderful. So before I talk about what you're going to be learning today, I'll just give you a bit of background about me. So while I work for Legal Aid Queensland, my background is in counselling, particularly with women affected by domestic and family violence. So the legal information that I'll be providing is of a general nature only, and I cannot provide any legal advice because I am not a trained lawyer. Like Catherine mentioned as well, because we are Legal Aid Queensland, we are focusing mostly on the Queensland context. Domestic violence orders are recognised across all Australian states and territories as well as in New Zealand, but my information will be focused on Legal Aid Queensland services, which are Queensland based, as well as my experiences of working with people applying for domestic violence orders, which has been in Queensland and namely mostly in Brisbane. So what we'll be covering today is some information about how people can apply for domestic violence orders, how people can respond to domestic violence orders. I'll be briefly touching on the Referral Pathways program and how it can assist vulnerable clients, as well as some general other referral options for clients into Legal Aid Queensland. I'll be going through some common terms. For some of you who may not help clients apply for DVOs very often, some of these may not be as recognisable to you, so I just want to make sure we're all on the same page. So the aggrieved is usually the person identified as most in need of protection. The respondent is the person who is responding to the DVO, and the applicant is the person who has applied for the order. This may also be the aggrieved, or it might be someone else, say the police, applying on the aggrieved's behalf. Other common terms include a named person, so that could be a child or family member of the aggrieved listed on the DVO as an additionally protected person. A mention is usually the first court date for the DVO application to be looked at before a magistrate, and a TBO refers to temporary protection orders, and I'll explain a bit about what those are soon. So just to make sure again that we're all on the same page, domestic and family violence is a very broad term, but typically it's behaviour from a person that you are or have been in a relationship with that is physically, sexually, emotionally or psychologically abusive. It could also be threatening, coercive, or any other behaviour that causes you to fear for safety or well-being, or for that of someone you're close to. DVOs, or domestic violence protection orders, are civil orders made in the magistrate's court. So they are designed to protect someone from domestic or family violence. Like I said, a person can apply on their own behalf or someone else can apply on the client's behalf. Generally, they're made for up to 5 years and they are recognised, like I said, in Australia and New Zealand as well. In terms of who can apply for a DVO, you can apply for a DVO if you're experiencing violence or have experienced violence in a relationship. So the typical things you'd see is people who have been in an intimate personal relationship, so they've been a couple or married, a family relationship, so it could be a parent or a sibling. Less commonly, but still important, are the informal care relationships, so where someone is dependent on another person taking care of them in daily activities. Legal Aid Queensland has a really great fact sheet, which is attached as one of the handouts, that explains not only about how to get a domestic violence order, but some of the behaviours that are considered domestic and family violence. So it has some examples in there. Like I said before, there are temporary protection orders. So DVOs can either be temporary or they can be a final, which is the long-term up to 5 years order. Temporary orders can be made in the meantime while a decision on a final DVO is being decided. And domestic violence order puts limits on what the person responding to the order is allowed to do. So they have to be well behaved is the wording, towards the aggrieved and of good behaviour. So I'll be talking a bit more about what's involved in a DVO. The other thing I just wanted to mention in here, obviously, is while a child can't apply for an order, if they're under the age of 18 against a parent, children may be named as additional protected persons on an order.
Thanks, Daisy. We did actually have a question around what support or referral options are available for children who witness a domestic violence situation or are in the home at the time a domestic violence incident occurs. Is there anything else you're able to touch on about support?
Yeah, so in addition to, I guess, being named as a protected person where the respondent would have a responsibility to not expose the children to domestic and family violence, we'd always encourage clients who we're supporting to get a DVO to make sure they're connected with a support service. So it might be a DV specialist service. A lot of these services have support and counselling set up for children and young people. And obviously there's other things like Kids Helpline that children can speak to as well.
Thanks, Daisy. Another question came through about what to do when someone's in a situation where they need to apply for protection, but there is already a DVO in place.
Yeah.
Are there any other options for people in that situation?
Yeah, so I'll just touch on that. So if a DVO has been applied for and someone is listed as the respondent, but they actually need a DVO to protect themselves from future violence, they can apply for an application where they are the applicant and they are talking about the protection they need. That then becomes a cross application. So there's applications on both sides. And that's typically then when a magistrate would look at hearing both of those together, assessing what's necessary to protect the people involved in this from the risk of future violence and what sort of conditions need to be made to try and minimise the risks.
Thanks, Daisy.
So like I said, there's a lot of different options for clients when they're applying for a DVO. Your standard conditions, like I said, are that respondent must be of good behaviour towards the aggrieved, not commit any domestic violence towards the aggrieved, as well as any other named persons such as children or family members. In a DVO application, a client needs to be providing their details, so the aggrieved details, the details of the person they wish to seek protection from, so the respondent. They need to be explaining what type of relationship they've had or are having. They need to be talking about the grounds for why they believe they need a domestic violence order application, so what abusive behaviours have been occurring, considering whether or not they want to name any people additionally to be protected, making sure they've flagged if there's any other court orders in place, like family court orders, talking about conditions, and I'll go into that in a bit more depth, as well as flagging whether or not they want the court to make a temporary protection order. So above and beyond the standard conditions, there are extra conditions. So one of those is an ouster condition. So that means they are asking for the respondent to leave the home. A no enter or approach condition. So that's stopping the respondent from being able to show up where the aggrieved works, lives, or stays. Stopping them from being able to approach them in person. Stopping them from being able to contact them, so by phone, social media, SMS, email, what have you. Stopping them from attending any place associated with the child, school or daycare. Stopping them from being able to locate them or ask someone else to locate them. And recovery of essential property. So if they've got belongings that they need to recover from the family home and the aggrieved has left the family home and they wish to retrieve those belongings safely, they can put that in the application to be considered. Obviously, reasons have to be given to the court for the court to consider whether or not it's necessary for those additional conditions to be made, but those are the extra things that people can ask for.
Thanks, Daisy. We've had a lot of questions coming
yes,
on this application form. So, if I can interrupt you and ask a couple of these. Someone's asking for clarification around who can make an order. Can a court decide to make an order with no application from a person, or could QPS decide to make an order, or does it need to come from somebody in that domestic violence situation?
Yeah, so like I said, a person experiencing violence can apply for an order on their own behalf. Police can apply for an order on someone's behalf. Occasionally the court may make a application on someone's behalf, but it's the least common applicant, I guess. It's usually the vast majority is actually police. I think it's about 85%, and then about 15%, I think, is made up of private applications in the court. So if the police apply for an order, it's a police protection notice can be made, and that's a sort of temporary thing until the client gets to court. Then the magistrate will hear it at that mention and determine, do they need to make a continuing temporary order, or can they make a final order? If a person applies on their own behalf, again, they can ask for a temporary order before their first court date, and then the magistrate will hear the order in the mention, hear the application in the mention, and determine, okay, what needs to be happening next. So the court, when I say the court can make an order, it's a magistrate in that magistrate's court making an order. So there's many magistrates courts around Queensland, so it will be whatever court that the person has applied to.
Thanks, Daisy. Someone's also had a question around incorrectly being listed on an application for a protection order.
Yeah.
Particularly around people from culturally and linguistically diverse backgrounds. If somebody feels like they should have been listed as the aggrieved but had actually been listed as the respondent, is there any way to protest the order or make a change?
Yeah, so I'll be touching on that a bit more in the responding to DVO section a bit later on with my slides. But yes, I agree. It can be very common for women from COLD backgrounds to be listed or mislabeled as the respondent when they're actually the person most in need of protection. When I was doing court support at the Brisbane Magistrates Court, we would see that fairly often. So I say first and foremost, it's super important for that client to get some legal advice so they understand what's required of them now that they've been listed as a respondent. It's super important that they connect with a DV support service so they can make a safety plan and make sure they're getting that support. In terms of other steps from there, the client might be able to apply for, like I said, a cross application. So if they're applying for an application seeking protection for themselves from the other person, and they can also apply to vary the order where they're listed as a respondent, or they can contest the order where they're listed as the respondent. But in that scenario, and in all of these scenarios, it's super, super important for the client to get targeted legal advice about the application.
Thanks, Daisy. That's really important information, and I'm sure would have been really helpful. Someone's also asking if it's possible to add children down the track to an order.
Yeah, or change conditions. Yeah. So once a person has applied for a DVO, they can also apply to vary a DVO. So a person who is the applicant or the respondent can apply to vary a domestic violence order. So it's similar information that you put in the initiating application, but it's a shorter document. It's about 4 pages compared to the 8 pages of the applying for the DVO document. So they've got to list what the existing order is, so what court it was made and when it was made. Then they've got to talk about what changes they want to make. So if they want to add children to it, if they want to add extra conditions, if they want the court to remove some conditions, these are all things they can ask for in terms of what they want varied and why. So it's super important that they're putting in those really clear reasons as to why they think the court should consider it necessary to change those conditions or add conditions, remove conditions, etc. But again, it's also really important that that client is getting legal advice. But certainly anyone can apply if they're the applicant or respondent to vary a DVO, and it's up to the magistrate to determine whether or not they do actually make those changes.
And Daisy, is it a similar process? Someone's asking for removing the DVO altogether.
So it's a lot more involved to ask the court to remove a DVO than it is to ask to vary it. So that would definitely be a situation where the client should have a chat to a lawyer and get some advice about the likelihood, considering the situation, you know, the different options. If the court doesn't remove it, you know, what other things they can do. Because the court has a responsibility to make sure that they're not exposing people to the risk of violence. So they, particularly when police have applied for an order as well, the police and the magistrate both need to be satisfied that the removal of this DVO isn't going to put anyone at due risk. So yes, you can apply to vary DVO and give grounds as to why you think the DVO should be removed or the condition should be removed. But again, the magistrate needs to be satisfied that that's going to not place anyone at risk. And if an order has just been made and someone applies the next day to vary it, the magistrate will go, well, you know, are you actually providing any additional information for me to consider why it's necessary? So it might be that the client should sort of have a think about, okay, what are my options? What do I want to do next? And what's the risk of going forward? Yeah.
Thank you, Daisy.
And we've got that other question about cross DVOs. So person using violence applied for a DVO and threatens the victim survivor to not attend court and defend themselves. So obviously, if a person has been listed as a respondent, whether or not they are in fact the true aggrieved or a true respondent, it's super important for that person to make sure they've spoken to a lawyer and that they do attend court if they want to participate in the court proceedings. Obviously, if they're not at court and they're the respondent, an order might be made in their absence if the court thinks, well, you've had an opportunity to come and respond, you haven't done it, you know, an order might be made in their absence. Likewise, sometimes aggrieveds are told by police, if police have applied for them, you don't need to attend court. And it may be that it's not safe for them to attend court and they have to determine that themselves. But it's also important that clients attend court if they want to make sure that they're having a voice in that process. So if they're pleased to apply for the order, but they think, oh no, I actually need more conditions, or I want to get some advice, or I want some support at court, then it's super important for both parties to participate so they can have that voice. So in terms of a time frame, I'd say, you know, if a person is served with documents saying that they are the respondent, they should be endeavouring to attend court on the date that the court date is listed.
Thank you. And I can see some more questions coming through around that. And unfortunately, we can't answer specific client questions today. But I would strongly encourage you to get in touch with us. And we've got an email address on a slide at the end where you can email through and get some more support once the webinar's finished.
Yeah. And the final thing I'll just say on that is, if clients want to participate in court, but they've got concerns about actually physically being at court, they can ask for permission to attend court by phone. So they can still participate, but they're obviously not at court where they might be victimised with it.
Thanks, Daisy.
All right. So we've got another poll.
All right.
This is just to check that you've actually been paying attention and you know what I'm talking about.
All right, so Alex has experienced domestic and family violence during a relationship, and it has continued post-separation. Alex is worried about the children being exposed to the violence. So what are Alex's options?
So looks like those might be the old questions.
All right. We've just got a little bit of a technical error with our questions today. So rather than running it as a poll, we're just going to ask you to think about this. Do you think that Alex should be getting legal advice, or instead organising counselling for the children, applying to a very existing DVOs to name the children as protected people? Or do you think that Alex could actually go with all of these steps? So just give you a moment to have a think about which answer you would preference here. And Daisy, I might ask you to talk a little bit about this situation as well and provide some guidance around here too.
Yeah, so I guess the answer in this circumstance is she could do any of the above. Yeah, a lot of people are saying D, love it. So all of these options would give Alex the option to get information, support, and action on her matter. It's always important, like I've said probably about a billion times already, for clients to get accurate legal advice about their situation, especially since we know that in domestic and family violence that can change so quickly. So it's really important that they get advice as well as having adequate supports in place. So getting legal advice would be important. Organising counselling for the children and herself would be important, as well as she could apply to vary the DVO to name the children as protected persons, and that would give the court the opportunity for the magistrate to determine whether or not that's necessary.
Thanks, Daisy. All right, back into temporary protection orders.
Yeah, so I mentioned these before. So people need to consider whether or not when they're applying, if they want to ask the court to make a temporary protection order, or TPO. So TPOs can be made ex parte, which means in the absence of the respondent, if the client is seeking protection from the respondent before the respondent is served with the order. So if they've done their application, they lodge it with the court, they say, I want an urgent TPO today, then if they're there at the court and the court determines, okay, yep, let's do this, then they might be heard urgently by a magistrate on that day. Obviously, this is only Monday to Friday, because that's when the courthouses are open. If they need an urgent TPO on another date, they might need to look at other options. So TPOs are typically in place until the next court date or until a final decision on a DVO is reached. They have to provide reasons for a TPO. Some of these reasons, from my own experience in helping clients with DVO applications, might include things like high-risk DV, so it could be strangulation, threats to kill, weapons, could be concerns about the respondent's retaliatory, negative, abusive reaction to being served by police with the application. Could be the client's fear for their physical, emotional, or psychological safety, or that of their children and family. You're usually wanting to provide information about the incidents that have happened recently. So in the last sort of 2 weeks or so, because that's showing that, okay, things are happening right now and they really need that protection right now, as well as whether or not there's been an escalation of violence. So has there been an increase in the amount of violence that's happening, or the intensity of violence that's happening, or how quickly the violence is happening in that cycle of violence. So those are some of the things. That's not an exhaustive list, but those were usually the typical things that would come up when a client was providing reasons for applying for a TPO.
And Daisy, someone's asking if there's room to discuss the difference between a PPN and a TPO.
So TPO, temporary protection order, PPN, police protection notice. Obviously, if you're an applicant yourself, you can't do a police protection notice. You would do a TPO. I'm not going to get too far into it because, again, I'm not a lawyer, but my understanding is the police protection notice is that sort of temporary notice that a police might put in place if they've attended an incident and they think, whoop, we really need to put some protection in place now. That will then stay in place until the court date. So it's sort of the police's version of a temporary protection order, I believe. That is my understanding.
Thanks for clarifying that, Daisy. If you have room for another question.
Yeah, go for it.
Yeah. Someone was also asking what are the risks of implementing a DVO in the circumstance that the violence might then increase?
Yeah, so unfortunately, there's many times in a domestic violence situation where violence may increase. We know that at any sort of time where there's a change or transition, so separation, pregnancy, or court proceedings, can be times where violence may increase because the person using violence is feeling that they've got less control over the person that they're abusing. So applying for a DVO may increase the risk of violence or may increase the intensity of violence. So it's super important for clients to assess, okay, based on what's happening for me, what is going to be the best decision for my safety or the least worst option, and what might give me the best chance of protection. At the end of the day, it is an order, but it is a civil order. It's asking the respondent to be a good behaviour. So if the respondent is disregarding the order and breaching the order, it's important for the client to be reporting those breaches to the police. But it's also important that when they're doing an application, that they're making sure they've already connected with support. They've already got a support plan. They've already got an idea in place of, okay, if the respondent reacts really badly to this DVO and I'm in danger, do I have somewhere safe to go? Are the children safe if there's children? Do I have supports? You know, am I making sure that I cannot be located if he doesn't know where I am? So those are really important questions to consider.
Of course. Thank you, Daisy.
All right. So I've talked a bit about this already. Obviously, get legal advice. So that's our call centre number. So if someone's been served with a DVO, it's super important for them to get advice. I'd always encourage someone, if they're a respondent to a DVO, to go to court so they can actually participate in the court process and have a voice in the process. So they can consent. So that's agreeing to the order. So respondents can consent with admissions or without admissions. So what that means is they can say, yes, you can make the order, but without admissions means, yes, you can make the order. I don't agree with what's in the order, but yeah, sure, you can make it. Consenting with admissions is saying, yes, you can make the order, and I agree that what's in there is accurate. So unsurprisingly, most of the time, if someone's consenting to the order, it's usually consenting without admissions. Okay. If a respondent has been served with an order and they haven't had a chance to get legal advice, either before court or speaking to a duty lawyer for free at court on the day. They can ask for an adjournment, so they're asking for the court to postpone making decisions until another court date, and that will give them time to go away and get advice if they need further advice. They can contest, so they can say, I completely disagree with this order, I don't want it made. The court will take that to consideration, and it's likely that that will be set down for hearing. And both sides will need to provide more information for the magistrate to make a decision.
Thanks, Daisy.
Or they can do nothing. And if they don't come to court and they don't participate, an order might be made in their absence.
Thanks, Daisy. Someone's also asked about when a domestic violence order has been made against a respondent that holds a blue card or a yellow card.
Right.
They're wondering if there's any impact of that, particularly if they have children. Are they, I guess a second question in here is, could they also be perceived as being alienating their children if they don't have contact with them?
I'm not super familiar on the whole blue card, yellow card thing, so that's probably not something that I can answer just because I don't want to give you wrong information. That might be something that if you've got a question, calling our call centre and seeing if some advice can be provided on that by someone far more qualified than me in that area. But the thing of the matter is, a domestic violence order is a civil order, so it's not going on someone's criminal record, so that shouldn't, you know, create barriers in terms of that. It only becomes a criminal matter if someone breaks the order. So if they breach the order and they're not following the order, otherwise it's a civil order. In terms of no contact DVOs being perceived as parental alienation, again, that's probably more of a legal question than I can really answer. Again, if a court has determined it necessary for extra conditions beyond the standard conditions to be made, such as no contact, it's important that people get advice about what that means, and if they have a family court order, how the conditions on the DVO interact with the family court order.
Thanks for that, Daisy. Can a person apply for a domestic violence order against a stranger or a friend for an assault?
So, like I said before, the relationships covered under the Domestic and Family Violence Protection Act of 2012 cover intimate personal relationships, so like couples, family relationships, and informal caring relationships. So strangers, friends, colleagues, neighbours, any of that aren't covered under the Act. It might be possible for a client to apply for a peace and good behaviour order if they need protection from a person that's not covered under the Act. But in that circumstance, it's really important that they're getting advice, but also potentially reporting the assault to police if they feel comfortable to do so, and seeking out support for themselves so they can make sure that they've got some safety options in place.
Thanks for that advice, Daisy.
All right, what have we got next? Oh, our resources. So like I said, and like Catherine said, a lot of these resources, well, all three of these resources are attached as handouts. The How to Apply for a Domestic Violence Order booklet, I think, is about 70 something pages. So it's a hefty resource. We'll definitely make sure that the links are sent out. But that booklet is really handy because obviously it goes through the steps of applying for a DVO, what is domestic violence, as well as it includes some sample text and some sample forms. So it's a really good resource, and that was something we'd often share with clients. The Responding to a DVO application booklet is really handy if someone's been listed as a respondent. And the How Do I Get a Domestic Violence Protection Order, Your Legal Options Explained fact sheet talks about examples of DV, who can apply, and how do you get a DVO. So those resources are really great, and they're all on the LAQ website, and can be downloaded as an electronic version, but also you can order any of the resources to give to clients.
And that's all free.
Yeah.
And you can get as many as you like delivered to your
As many as you
centre.
like, as many times as you like.
Yeah, that's right.
Yeah.
And before we go off the topic of domestic violence,
Sure.
Daisy, we had a few more questions that had come from our audience ahead of the webinar. So I'd like to run through a few of these. All right. The first question is there any support or information that you're able to give our audience today about housing situations when when there is domestic and family violence, specifically who gets to stay, who needs to leave, who decides that, and also someone's just asking what an ouster order means as well on top of that.
So I'll answer the last question first. Like I said, the ouster order is one of the additional conditions that can be applied for when someone's applying for a DVO. So ouster means that they're asking for the respondent to be having to leave the premises, and they've got to put down the address. So that's what ouster means. In terms of housing situations where there's domestic and family violence, unless there's an ouster order in place, there's no rule about who stays, who leaves. What we would often do with clients where they were living in the family home with the person using violence is we'd have a chat with them and say, okay, if you needed to leave the home because it's not safe for you to be in the home, do you have any friends you can stay with, any family members? Do you have any other safe options in terms of accommodation? You know, do you have the financial means to stay in a hotel for a short time before, you know, court proceedings are finalized? And if they didn't have any of those options, we'd also have a chat with them of, okay, would you be comfortable going into a refuge? Do you want me to connect you with DV Connect? So we'd explore those options with them. Obviously, at the end of the day, it's awful for someone experiencing domestic violence to also have to then uproot themselves and potentially their children and leave. But it's about weighing it. Okay, you could stay here, but are you going to be more at risk because the other party is not likely to leave? You know, is it safe for you to remain in the house? So we'd never say you have to leave, because it needs to be a decision that the client makes about their own safety. We would present the options, but it's really about them working out, okay, what's going to be the safest short-term decision for me right now? Obviously, the rental crisis at the moment isn't helping, so we don't want anyone to be homeless. So we'd always look at, okay, what can you draw on in your informal networks, and then what can we look at in terms of support services? So other than an ouster condition, the court isn't determining any decisions about who leaves or stays unless that ouster has been asked for.
Thanks for clarifying that, Daisy. We've also got a question about what services could be available for young people who are exposed to domestic and family violence, where the domestic and family violence that's happening is between the parents, the kids are in the house and they're witnessing it.
Yep.
They're under 18. Are there any support services that they could be referred to?
Yeah, so like I said earlier, a lot of the domestic and family violence support services offer counselling for both adults and for children and young people. So I would say first point of call would be looking at local domestic violence services to the client, and seeing if they provide children's counselling. Domestic family violence counselling services are free for children and young people as well as adults. Obviously, there's a range of other services for young people. So, you know, you've got Kids Helpline, there's Headspace, but also if young people want advice about what options are available to them, they're also welcome to call Legal Aid Queensland themselves if they've got concerns. Like I said earlier, children under the age of 18 can't apply for a DVO against their parents, and parents can't apply for a DVO against their children if their children are under 18. The only time when a child can apply for a DVO when they're under 18 is if they've been in an intimate personal relationship. So if a child's got concerns, or a young person's got concerns about their parents using violence in the home, hopefully there's a safe parent that can connect them in with supports. But if there isn't, then it's about the young person seeking advice, either from a legal service as well as counselling support from a counselling service.
Thanks, Daisy. And I know you touched on this question throughout the presentation, but just for a little bit more clarification, what would be the best thing to do when the victim feels like it's the abuser that's taken a domestic violence order out on them?
Yep. So like it was covered before, sometimes the victim survivor is named as the respondent, even though they are the person in most needed protection. So like we talked about before, super important for them to get advice, important for them to go to court so they can participate in the matter and so orders aren't made in their absence, as well as they can apply for a cross application if they themselves need protection, and they can also contest the order, so disagree with it, which may mean that obviously they have to participate in a hearing with the person that's used violence against them, but that will give them a great opportunity to provide information about why they're the person that needs protection and why the order against them is inappropriate.
Thanks, Daisy. And there's just one more question on domestic and family violence, and you did touch on this already.
Sure.
Someone's just after a little bit more clarification. Could you please explain again the difference between getting a domestic and family violence order from within a family network, the difference between that and a separate order for someone who's outside of the family?
Yeah. So right. So if a person A has a mum that's also been victimized by the person that's victimizing person A, person A applies for a DVO because they are seeking protection from the person that's been abusing them, but they're also really worried about the abuser abusing their mum. Person A applies for the DVO and they ask for their mum to be a named person. Mum can't apply against the abuser unless there is a relevant relationship. So it might be, well, they want to apply because it's their son-in-law. That's a family relationship. But if there's not a relevant relationship, family members can't apply for DVOs against the abuser if there's not that relevant relationship. So definitely there's the option for family members to be added as additionally protected persons, but it just, yeah, it depends on whether or not there's that relevant relationship there. And yeah, we've just had before, so just to clarify, minors, i.e. persons under 18, can't apply for DVOs against a parent or family member if they're under 18. And likewise, parents can't apply for orders against their children if their children are under 18.
Thanks, Daisy. And we'll have to cut the questions there and move on to
I know, there's so
referral
many.
pathways, but we do have an email address at the end.
Yes,
so
yes.
Please, you can
Always happy to
email
have a chat.
or call up, and yeah, we can continue the conversation.
I mean, it's great. I'm thrilled that you've got so many questions. I just wish I had, you know, more time.
Yeah.
So we just had another poll, but we've sort of, because we're short on time, I'll just run through this rather than launching this as a poll. So child experienced domestic and family violence from their former partner for a number of years. They've just been served with DVO where they're the respondent. Obviously, we've just talked about all these options. So for Charlie in this scenario, should they get legal advice? Should they apply for a cross application? Or should they seek to vary the DVO where they're named as the respondent? Or should they do all of the above? Well, like we've been talking about, all of the above are appropriate options. So Charlie really needs legal advice to understand their options and what to do now that they've been named as a respondent. They can apply for protection they can apply for protection for themselves, which is that cross application, and they can also seek to vary the DVO because they are named as a respondent. So respondents and applicants can both seek to vary the DVO. Still up to the magistrate to decide, but that's certainly an option up their sleeve. So the Referral Pathways Program. So this is a warm referral pathway for vulnerable clients to connect with Legal Aid Queensland. It doesn't replace any of the existing pathways into Legal Aid Queensland. It's just an additional option where clients might not have capacity to self-seek legal advice. We have a Referral Pathways Program in most Queensland regions where LAQ has an office. We just don't currently have one set up in Mount Isa, Cairns, Rockhampton, or Inala. And Inala is sort of considered as part of the Brisbane Referral Pathways Program. So like I said, it's a warm referral process. So agencies working with a vulnerable client will warm refer the client to Legal Aid Queensland for Legal Aid Queensland to then get in touch with the client and provide timely advice. The Referral Pathways Program is set up for situations where the client needs advice about domestic and family violence, family law, and or child protection. We're very happy for agencies to use this. However, agencies must complete training with Legal Aid Queensland to register as a referral partner before they start using this warm referral pathway. So the email address I have at the end is everyone is welcome to get in touch with me if they want to inquire more about becoming a referral partner. The other thing I'll just say on the Referral Pathways Program is the design is for the local regional office to provide that advice first and foremost. And if that local office can't action it, it's sent to our Brisbane office so that they can call the client. It's designed to provide timely advice, so 1 to 2 business days. And it's really designed to make sure that vulnerable clients don't fall through the cracks because it's designed for clients where otherwise they may not connect with Legal Aid Queensland. So that's the Targeted Referral Pathways Program. More than welcome to get in touch with me about registering as a referral partner. I'm just going to talk briefly now about some other services that LAQ offers. Again, the Referral Pathways Program is just one pathway into Legal Aid Queensland. There's many options. So we have our duty lawyer services. So I mentioned this earlier. So clients can get advice on their day of court. It's free. So we have duty lawyer services all across Queensland at various magistrates courts and children's courts for DV and child protection. We also run a family law duty lawyer service at the Brisbane Federal Circuit Court and Family Court of Australia. And we have our family advocacy support service there as well. FAS, or the Family Advocacy Support Service, is designed to cover all of Queensland, but in person at the moment it is at Brisbane. We are expanding out to other circuit locations, but we're just trying to get staff and capacity to stabilise for that. So the Family Advocacy Support Service is a step up from usual duty lawyer services, so they might be able to do a bit more negotiation on the client's behalf. It's designed for urgent family law matters where perhaps they need to do a recovery order of a child or stop the child from being taken out of the country. With our DV duty lawyer services, family law duty lawyer service, and our family advocacy support service, we do have embedded support workers. So at the Brisbane Magistrates Court, we have a dual model of the duty lawyer and a support worker, and we have that as well at the Brisbane Federal Circuit Court. So they can do safety planning and referrals and crisis counselling. So that's also what I was just talking about. So info about court on the day of support. We also run an application assistance program only for the Brisbane Magistrates Court on Mondays and Fridays. So support workers can help clients apply for a domestic violence order, as well as help clients apply for a legal aid grant of aid form. And they're also at the Brisbane Federal Circuit Court as well to provide assistance, and that's Monday to Friday. So on the day of court is Tuesday, Wednesday, Thursday, because those are the days that they have DV court, and then Mondays and Fridays for application assistance. And these are support workers, so they're not lawyers, so they can't provide advice. We mentioned before our call centre, so that's the 1300 651 188 number. We also have some other targeted hotlines. So we've got our Indigenous hotline, our Youth Legal Advice hotline, and our Counselling Notes Protect line. And that's to get advice about keeping sexual assault counselling notes private during court proceedings. We also have the option for clients to apply to Legal Aid Queensland for a lawyer to represent them through our grants of aid. Many of our local LAQ offices also run phone and or in-person advice clinics. So get in touch with your local legal aid office to see when they are running. I'd also like to briefly mention our Child Protection Early Legal Service. It is an agency referral pathway only, so clients can't self-refer, but it is for clients who have child protection concerns before court proceedings are underway. If court proceedings start, they can apply for a child protection grant of aid, but if they need help before that starts, the Child Protection Early Legal Service might be able to assist. So that's the email address to get in touch with the team to become a referral partner. All right, got some takeaway tips. Great. So hopefully you've learned from this that clients can apply for new, varied or temporary protection orders or DVOs. Hopefully you're also aware now of some of our additional resources that are available not only to help you in your practice, but to give out to clients to provide information, and that there are multiple ways that clients can reach Legal Aid Queensland for advice and help, in person, by phone, etc. So we do try and make it as accessible as possible.
Thanks, Daisy. Now we've got about 3 minutes left on the clock, and we really appreciate how many questions our audience have for Daisy today. So we might try and get through a couple more before we go.
Yeah.
So on referral pathways, are there any extra support services by government agencies particularly that can help vulnerable clients?
Yeah, so I mean, obviously the Referral Pathways program in Legal Aid Queensland is designed to support vulnerable clients so they're not having to retell their story as many times, and so they can get targeted advice. Vulnerable is a very broad term, so it's important, I guess, depending on the type of assistance the client needs, whether it's support, legal advice, housing, whatever, that they're talking to agencies set up for those things about what additional support is available if clients are finding it hard to communicate, if they lack capacity, or if they're traumatized, as well as if they've got difficulty communicating because they're Indigenous or they're culturally and linguistically diverse. For Legal Aid Queensland, it's always available for any clients to get advice and assistance with an interpreter. That's free. So any legal advice can be provided with the aid of an interpreter or a translator if the client is deaf. And our support workers at court and by phone also can engage an interpreter where required. So a lot of our resources as well are translated into a lot of common languages. So again, we're trying to make it as accessible as possible for vulnerable clients.
Thanks, Daisy. And you've also answered another question that we had sitting there in that
That's
one.
all right. I was like, joining the two.
That's right. So I think that's a wrap for us today. It's spot on 11:30. Thank you so much to our audience for coming and bringing a wealth of questions with you. And thank you, Daisy, for sharing all of your knowledge with us today.
Yeah.
It's been a really amazing webinar. It's been great to see that the audience can easily engage with you and have all their questions answered. And so we just really appreciate your wealth of knowledge as well that you've been able to share with our audience today. So thank you, everybody. And thank you, Daisy.
So that's the email address to get in touch with me. So that's me, Daisy. So if you've got any follow-up questions, you're welcome to send them through. Please don't give this email address to clients. And please note that I can't answer any legal advice questions that you send through. If you do email me with a legal advice question, I'm just going to tell you to call our call centre and get advice.
Thank you. So our number for the call centre, Daisy mentioned earlier, that's in the slide. So if you haven't already downloaded the handouts, go ahead and do that, and we'll send an email around with those and the link to YouTube once this recording has been published on our YouTube channel too.
Perfect. All right. Thanks everyone. Bye.